Good. And yourself?
I'm doing great. So let's begin up with your session, and I would be starting up with your introduction, and then you can take it from them. Do you have your presentation? Okay, you're sharing it. All right. So let me start with your introduction, and then you can take it from there. All right.
Okay.
All right. Just a second. So I would request all the participants to join in for our first keynote session that is headed by Shashank Upadhyay. So let me start with the introduction, and I will request my backstage team to drive in the audience here. If they are having any issues in the background, assist them. All right, so here we can begin up and get this rolling. So we have our first keynote session. That is, the topic is advanced topics in patent litigation and civil procedure, and I'm sure it's a very awaited topic in all of our conference, and everyone would eagerly like to listen. So we have our keynote speaker joining in, Mr. Shashank Upadhyay. He's a managing partner with Upadhyay Tank LLP. So over to you, Mr. Shashank. Thank you.
Great. Thank you, everybody, and thank you, IPR Gorilla, for having us having us today. So I hope everybody can see the slides. Uh, so just a little bit about me. I'm the founding partner of Upadhyay Tang LLP. We're a Chicago-based IP and FDA boutique law only. We have more than 25 years of experience. We deal mostly in the world of pharmaceuticals, medical devices, IP, and FDA law. Personally speaking, I've been a partner at many global law firms. I also was the client. I was either the general counsel or the chief of IP or chief of FDA regulatory law at several pharmaceutical companies around the world, and I was also an inside counsel at many medical device companies. I'm also the author of a 1,400-page book on pharmaceutical patent litigation and FDA law, and I've written dozens of other articles. So I'm really pleased to be here. Today's agenda, we're basically going to touch on why civil procedure matters when it comes to patent litigation. And so here are the three main topics that we're going to talk about in the 15 minutes that we have. So we'll talk about the lawsuit complaint, Rule 12 motions, answers and counterclaims, and the strategic use of discovery, and then motions for summary judgment. So if we think about, well, why does a session like this matter? Well, all patent litigation is based in the courtroom. And as a consequence, the courtroom rules of civil procedure will apply. Now, most patent litigators, they know the rules of civil procedure, but many times patent litigators will try to make substantive arguments based on the patent law. But those don't matter if the federal rules of civil procedure are not followed, because again, at the end of the day, the trial court is going to be running his or her courtroom using those rules of procedure. And these rules, and if you do know these rules, then you're going to avoid potential waiver of very good arguments. There's nothing more disappointing, especially when I was the client, that my law firm had a terrific idea to help me win my patent litigation, only to find out that, in fact, we were too late. And you have to think about the fact that what happens at trial is ultimately what gets appealed at the appeals court. And the appeals court is not going to review any arguments that are waived, no matter how good they are. So the most talented patent litigators are the ones that will often use the federal rules of civil procedure and as a procedural tool in order to win their litigation. So let's talk about the first one, the lawsuit complaint, Rule 12 motions, and answers and counterclaims. So when it comes to the lawsuit complaint, obviously this is the opening salvo in a patent litigation. The plaintiff, usually it's the patent holder, will file the lawsuit. And so there are different theories that we take when we file lawsuits on behalf of patent holders. Do we want to file the lawsuit but not serve it? And the purpose of that is that we have between 30 days, 60 days, 90 days to actually serve the lawsuit. Now, if we file the lawsuit, it's on file. The court dockets will pick it up and it'll be reported in some of the docket tracers in the news. And so the company, the defendant, should be aware within a few days that it has been sued, but there's no service yet. And why? Because many times you just want to secure your place at the courthouse. You want to have this first filed lawsuit. And then you're going to use this 30-day, 60-day, or 90-day period in which to talk settlement. Because now the defendant knows they have been sued. And now it behooves them to talk about settlement. Another thing to think about, when you draft the complaint in the lawsuit is how much detail do you want to put into this lawsuit or into the complaint. So there's a couple of different theories. The first one, of course, is the basic complaint. It's thin. Is it cheaper in attorney's fees to draft? Of course, because you're not writing as much down. Strategically, it doesn't reveal the litigation playbook. It doesn't lay out everything that's going to be part of the lawsuit. It doesn't really describe what the patent holder's theory of the case is going to be. But the problem is that it could suffer from a Rule 12 motion to dismiss, which we'll talk about in a few more slides. And then, in addition, you need to plead fraud with what they call Rule 9b specificity, right? So there is this tension in how much detail you're going to want to put into your into your complaint. So now let's think about a more detailed complaint. A more detailed complaint, of course, is more expensive to draft. You'll see complaints that are drafted that have an element by element analysis. They may even include figures or pictures of the accused device, pictures from the internet, product manuals, and then they actually include claim charts where they say, this is my patent claim, and this is what it requires, a machine having parts A, B, C, and D. And then in another column, it would have pictures or charts that would show why the accused device has parts A, B, C, and D. Now, why would somebody put that much detail in there? Well, many times they're drafted to avoid these Rule 12 motions to dismiss, based on the insufficiency, of the complaint. Right? Now, there's also a danger that the plaintiff may plead himself out of the court. In other words, the plaintiff describes certain things in the complaint that, if taken true, would mean that the case is actually over. Like the plaintiff knew about the infringement more than 6 or 10 years ago and now is suing. So it's hard for them to backtrack against that. So let's talk about Rule 12 motions. There's Rule 12, in the Federal Rules of Civil Procedure. There are 7 different kinds. They need to be filed before the answer. And the most common is the Rule 12b6, failure to state a claim, or the Rule 12c, motion for judgment on the pleadings. Now, we're going to talk about those in a little bit of detail in a second. And the Rule 12c motion is filed after the pleadings are closed, whereas a Rule 12b6 motion is filed before the pleadings are closed. So Rule 12 considerations and the Rule 12 failure to state a claim. Generally, it's used to throw out a thin complaint. There's not enough detail. There's insufficient plausibility under the so-called Twombly-Iqbal, which is pejoratively known as the Twickball standard. So in other words, your complaint can't be too conclusory. It can't say, I have a patent, he's an infringer, his product infringes, and therefore I deserve damages. There needs to be a little bit more. But the law does not require that the complaint prove the full case. And so again, this is where we see that tension between how thin do you have your complaint versus how much detail do you do. And as a consequence of a complaint like this, it could theoretically tip off the plaintiff as to the later defenses that can be raised. And on top of that, a plaintiff may choose instead to refile a complaint to cure any of the infirmities that may be there. Now, one of the things about a Rule 12b6 is that oftentimes after the briefing is over, the defendant says, I don't belong in this case at all. But notwithstanding, the court forces you to comply with the U.S. discovery rules and continue on. And you're thinking to yourself, if I'm not supposed to be in the lawsuit, why am I actually in the lawsuit in the first place and continuing? 12c motions are motions for judgment on the pleadings. They're used once the pleadings are closed, such as when the answer is filed. You ask for these, this is a real judgment. This is not just a dismissal like a 12b6. It can be used as a substantive judgment. You get a real court holding that there's infringement, non-infringement, validity or invalidity, right? And, again, as the slide details, there are different uses for the Rule 12c consideration. And interestingly here, you can also consider some extrinsic materials that are in the complaint, they're matters of public record, or they're subject to judicial notice. And your goal here is to get a judgment that says whatever it is that you're looking for and get a court order. So here's an interesting, practical tip. You can use a 12C motion for judgment on the pleadings, especially in the doctrinal equivalence. So I give an example here. So perhaps your patent specification has a laundry list of flavor ingredients in a formulation, such as cherry, grape, strawberry, vanilla, lime, etc. Your patent claim started broad initially to all flavorings, but it was narrowed in prosecution to just vanilla. So obvious, and then the accused formulation uses lime flavor. So there's no literal infringement because vanilla is not lime. And under the DOE, you would claim that because I'm using one of the disclosed, but actually not claimed flavors, this is a dedication to the public. So in an answer and counterclaim, as we kind of move on, you need to decide if you're going to be adding a plain answer with routine denials. You're going to be Rule 8C requires you to plead with certain specificity. And then you have to decide, are you going to include counterclaims? And you could include defenses that say, I don't infringe or the patent is invalid. Or do you want to include actual counterclaims in which effectively you're the plaintiff or the counter plaintiff saying this patent is not infringed and or this patent is invalid? And if you do file counterclaims, your counterclaims will be governed by the same rules as a normal complaint is. And so just be aware that you may also plead yourself out of court, when that happens. So let's talk about some strategic use of discovery in the last few minutes that we have. One of my favorite discovery tools is Rule 36 request to admit. This is a very often underappreciated and overlooked rule. It's often used for authenticating documents or confirming bibliographic details. So a request to admit or request for admission basically says something like admit XYZ. But when they're narrowly tailored, they can be used to extract admissions. And so this is what's key. And narrowly tailored makes it hard to make a denial. And you can't say, well, I don't know, as a basis of denial. And in addition, if the request to admit is not answered in 30 days, it's deemed to be admitted. So here's an example of a poor use of a Rule 36 request for admit. I've seen this happen a lot of times, and I just basically laugh because this was just a client wasting a lot of money paying a law firm to do something stupid like this. They say, admit that plaintiff XYZ company exhibits a pattern of fraud in prosecuting patents at the US Patent Office, or admit that company ABC infringes the patent. Nobody's going to admit that I'm never going to admit that I'm a fraudster, and I'm never going to admit that my product actually infringes, because those are conclusions of law ultimately, and findings of fact. So I can fairly admit that. But here's a good use of a Rule 36 request to admit. Admit that plaintiff XYZ company sold this particular model 123-45 machine in the United States before January 15, 2007. Or admit that model 12345 does not contain a metal rod that connects the widget to the gizmo. And the reason why these are good, because they're narrowly tailored, they are very, very specific. And as a consequence, they could be used to extract admissions. Now, here's the great thing. If you improperly deny a request to admit, and it turns out to be wrong, and the moving party proves that ultimately, you can get expenses, including attorney's fees. So imagine that you're trying to argue patent invalidity based on sale in the United States. Then as a consequence of that, you do a request to admit, and you admit that it was sold before January 15, 2007, and they deny that. And then you ultimately prove it, and it turns out to be the basis of invalidity. You might be able to get all your attorney's fees for the invalidity. Now, it's up to the court to decide, but again, here's a terrific way to use a Rule 36 request to admit in a strategic way. Motions for summary judgment are one of the last things, that we want to talk about here in an advanced civil procedure topic on civil and patent litigation. So here, summary judgment is akin to the early motions for judgment on the pleadings under Rule 12C. Again, you're here to get a judgment on a particular issue, right? And as a consequence of that, you are trying to get an adjudication on a claim or a defense. Now, under the 1986 trilogy of U.S. Supreme Court cases, summary judgment must be granted if there are no genuine issues of material fact. So what this means is the moving party will allege there are no genuine issues of material fact, proffer the evidence, and then the defendant or the non-moving party has to respond and show that there are genuine issues. Otherwise, summary judgment must be granted. Now, summary judgment will be highly affected by the trial judge's attitude of the summary judgment. Do they actually grant it, or do they still send everything to trial? The danger in summary judgment can be it provides a playbook for the later trial, and that could be a problem. And unfortunately, the case is not suspended during summary judgment. So your case will continue, and it may even go all the way through a trial, even though you're saying we don't even have to have a trial because summary judgment is pending. And you should also know if summary judgment is not likely because there's pending claim construction issues that are still unresolved. So for summary judgment, even though it requires no genuine issues of material fact, it can still be used to show non-infringement. The facts clearly show there's no infringement of each claimed element. Infringement, patentees obtain enough documents, to show that there is an infringement, or through depositions, and similarly through validity and invalidity, it's just the opposite. And summary judgment can be a powerful tool to help narrow a patent litigation case. So when it comes to summary judgment, you also have to know, where are you litigating? Now, we litigate our cases mostly in Delaware, New Jersey, Eastern District of Texas, Northern District of Texas, Northern District of California, Northern District of Illinois. So as a law firm, that specializes in patent litigation, this is what we do. And so we need to know the attitude of the judges. Some judges really don't care whether it's expensive for you as a client, but they care more about managing the case flow, for them. So you need to understand, is this trial judge never going to grant summary judgment because other issues remain? I.e., if the case is going to go to trial anyway, who cares? Don't bother granting summary judgment. So you need to understand what the timing is. So in conclusion, civil procedure underpins patent litigation. You need to know your local rules and recognize that post-patent litigators only know the basic everyday rules, but exceptional patent litigators will know the advanced topics, and you should use it to your advantage. So if you're considering patent litigation, just want to give a shout out to our firm. This is what we do. We specialize in patent and commercial lit. We help clients, on the litigation and on appeal. For our purposes, our firm practices Lean Six Sigma and project management skills so that we provide these clients with efficiency, transparency, cost controls, and high quality. And if you have any questions, thank you very much. I appreciate the time, and thank you again to IP Gorilla for having us.
Thank you so much, Mr. Sushank, for a wonderful topic discussion, and also starting the day with the keynote session. So, participants, do we have any question for Shashank? So, you can drop down on the chat box, or you can come face to face and ask him directly. So, in the meantime, if you can, stop the screen sharing, Shashank, so we can also take a click along with you. Thank you. So we have a comments on the chat box that is from Dr. Amit Kumar Tiwari. He's saying excellent insights on patent litigation and civil procedure. Many thanks, Shashank. So appreciate it. So we have applause from Kavita. All right, thank you so much. So participants, we have a polling at the poll section. You can do your polling for this particular session, and we can provide him the feedback. And Barrett enjoyed the presentation. Regwinder saying excellent insight. We have an applause from Krishna Singhania. All right, so as soon as
the
you
most
drop
important
down,
thing is we finished on time, right?
absolutely, and very much punctual. I appreciate it. So Gia, we have a question from Gia Tang. Does your firm also help with trademark and design infringement cases? I will be in touch.
Yes, we do. We do the full gamut of trademark and design infringement, Lanham Act, and unfair competition, because trademark work can also be unfair competition.
All right, thank you from Gia. So you can be in touch with him. All right. So yes, okay, you have written. All right. So do we have any more
Okay.
questions, participants? You can join face to face, or you can write down on the chat box. So let's have a quick smiley screenshot, Shashank, and take all the memories along with you for having you in today, like in morning today, and also having the insight about this wonderful topic. So let's, my backstage team, if you can take a smiley screenshot and all right. Thank you so much, Shashank, for
Thank you
joining
very
us
much.
today. And we're looking forward to have your participation for the whole day because we are having interesting topics coming up and lined up in the whole day conference. And also wanted to see you at the end of the day where the surprise awards will be announced and you can be a speaker of the day.
Okay. Thank you.
All right.
Thank you,
Thank you so
everybody.
much. So, to all the participants, kindly do the polling at the poll section before you leave. And let's move forward to our first panel discussion that is just beginning up in 4 minutes from now. All right. Thank you. See you all there. And let's join from the sessions again to the new session, new panel discussion that is coming up. So the next panel discussion is what are the major risks in IP licensing, identifying the gaps and solution in IP license processes in different industries. So looking forward to see you all there. Bye from here.